such choice. This is quite interesting because here, as you can see, they upheld the choice made in an arbitration and considered that the arbitration clause will not be upheld in this particular case. This brings us to the importance, tremendous importance of drafting a proper and correct arbitration clauses in any agreement in case the parties really wish to submit their disputes to arbitration, because any similar, let's say, a mistake would lead to the court not to uphold the arbitration clause. I do not know if this has been appealed, therefore I'm only relying on the first instance ruling. I'm referring here to the cassation court's rulings that were issued lately in 2019 and 2020. And in both cases, the cassation court has considered that the appeal court ruling in a case of setting aside an arbitration award is not subject to appeal by any means of appeal. I'm referring here to all the articles in the arbitration law that confirms the same, not only in setting aside arbitration awards, but also in other cases. I move on now to the QFC course, and we were delighted to see that lately there has been a note issued by the court whereby the QFC court has accepted jurisdiction to look into an arbitration-related manner, but declined the relief sought therein. The basis for the QFC court ruling are the court has heard an urgent application for interim relief relating to a proposed arbitration. The arbitration agreement set out that the seat of the arbitration be the Qatar International Court and Dispute Resolution Center in the QFC, Qatar, and the venue of the arbitration shall be Qatar. The court has also taken into consideration the fact that neither companies were registered in the QFC and that the applicant stated that it was still in the process for filing for an arbitration request in relation to the dispute, which means that at that point in time when the court issued this important decision, the arbitration had not started yet. But however, it has agreed to accept a jurisdiction over the matter, whereas the seat was within the court center. And this is very interesting. The other matters that also we would be looking for is that the arbitration law has now granted the right for the parties, even if they were not registered in the QFC, to agree on the civil and commercial code of the QFC as the competent court and on the enforcement judge of the civil and commercial code of the QFC for the purposes of the law. The law meaning arbitration law, which means that the parties now can insert in their terms of reference or in any other form of agreement their mutual designation of such court or judge for the purposes of the arbitration law. And the court and the judge are likely to rule in the near future on cases pertaining to arbitration, whereas there have been agreements lately by the parties to designate them as the competent court and judge. So we will see if eventually the appeal court, the appeal state court, and the QFC court would have the same decisions and rulings on same matter, identical matters, or whether there will be different court precedents on this subject. This, I believe, we will have to look forward to it, and hopefully we will have cases in the near future. And as Dr. Minas has said, if the Kika will have regularly webinars on these matters in order to be able to update the legal community on what is happening when it comes to court rulings and arbitration matters. Thank you for your patience. Thank you for the translators. I hope I was not very fast. And I'll be taking questions later on, I believe. Thank you.
Mrs. El Hage, thank you very much for this beautiful presentation and all the comments you have done on the different rulings you have mentioned. And we hope with your participation and all the community members of arbitration in Qatar, in the GCC, in the other Arab countries, as well as in European and the rest of the world, we can keep this date, and we save the date on our calendar, where we can do, of course, every year a kind of panoramic 360 degrees revision of all these updates. Well, now we are going to pass to the second speaker. We welcome Mr. Jonathan Parker, who is a practicing barrister, England and Wales, based in Clyde & Co. Doha office, and specializing in acting as a lead counsel advocate in domestic and international arbitrations. Mr. Parker is a chartered arbitrator and has been appointed in international arbitration proceedings under different institutional rules. He sits on various arbitration institution panels in the Middle East, Europe, and Asia. He is also a Royal Institute of Chartered Surveyors. I believe he is a member at the Royal Institute of Chartered Surveyors, and he is a qualified adjudicator. Jonathan has considerable experience in alternative dispute resolution, including dispute boards, expert determination, and mediation. Jonathan's principal sectors of works are construction, engineering, utilities, transport, infrastructure, energy disputes arising out of major capital projects. Jonathan represents clients in the common law-based Qatar International Court at the QFC, and is also member of the Qatar International Court Users Committee. Mr. Parker is going today to talk about a very update topic, which is virtual hearings in arbitration. Mr. Parker, the floor is yours.
Thank you very much, Dr. Minas, and thank you for the kind introduction. And may I say it's a pleasure to be speaking to you all today. Now, arguably, no talk on developments in arbitration would be complete in recent times, as Dr. Minas has said, without some reflection on virtual hearings. But a challenge perhaps comes in developing a talk like this, in the sense that so much has already been said. But I will try, I will do my best at least to give some views that perhaps haven't been debated so extensively. Now, many practitioners have viewed virtual hearings as a better option to waiting indefinitely for a physical hearing. And tribunals are, of course, under an obligation to deal with proceedings expeditiously. And that is why we get to the sort of central thrust of my talk today, which is when the time comes that the pandemic has ended and virtual hearings, or physical hearings, I should say, are a genuine option, will virtual hearings still be so abundant? Now, before getting into virtual hearings, I'd just like to start by saying we're already perhaps seeing in business more generally a retreat from the use of video conferencing platforms, or the Zoom boom, as some people have called it. And we're seeing various experts comment on the negative effects of Zoom on factors such as mental health, issues such as body dysmorphic disorder. And we're also seeing moves such as the American investment bank, Citigroup, introduce Zoom-free Fridays in the interest of shielding mental health. So perhaps we are already seeing in business more generally a slight retreat from the use of video conferencing platforms, although of course that's more likely to be a moderation of the use rather than a full withdrawal. Well, what about virtual hearings? I mean, a big question is, of course, do they work? And I thought it would be helpful to outline an example of a recent hearing. And The one I'll refer to, I acted as lead counsel in an evidential hearing for a construction dispute. I've picked this example because my co-counsel was the excellent Claudia El Hage, who's a panel member here. She joined from somewhere else in Qatar. The tribunal members participated from 3 different countries, and my opposite number was a London-based QC who, as is commonly the case, joined from a spare bedroom at his home. There were 6 experts giving evidence. There were 8 witnesses of fact, and all of those were cross-examined. Now, as is common in construction disputes, the evidence comprised hundreds of thousands of pages of documents. And then we also had the added complication that often comes with virtual hearings, which is a broad spread of time zones. And I think the participant time zone spread was something like 9 hours in this matter. Now, in practical terms, I used a screen in front of me, showing the witnesses and the members of the tribunal. I had another screen to my right-hand side, which displayed the evidence. And that was very fast and efficient, and often the evidence would be shown on the screen within seconds of me calling for it. Then I had a third screen to my left-hand side, which displayed the live transcription, which was being produced by a firm in London. Now, whilst all of that was going on, we also had a translator based elsewhere in Europe, who was making sure that the witnesses giving evidence in languages other than English could be understood, and also that the witnesses' evidence could be understood. So really, I mean, the example I've given is a strong testimony, I believe, to the technological capabilities. When it works and when it's all going very well, technology is capable of producing some excellent results in a virtual hearing. But with that greater reliance on technology and new working practices comes packaged novel opportunities for problems to arise. And in my experience, there have been a few. Now, in the hearing I've just referred to, there were issues with a expert witness's internet connection dropping out several times whilst I was cross-examining him, and obviously that's not ideal. There were also hiccups, such as one of the service providers left their microphone open and caught a flushing toilet in the background. I rather hope that was by accident rather than in protest. We, in that hearing, had somebody drafting an email without realising their screen was shared for everybody to see. And that's much like the common anecdote, and we've probably all heard of instances of somebody using the virtual hearing platform to send a message and sending it to all participants when they only intended to send it to their own party. Now, some of those are admittedly just annoyances, but some of them can be difficult issues. And I spoke to a colleague recently who sat as a tribunal member in a one-day hearing in which counsel for one party was just unable to join by the video conferencing platform. And the hearing proceeded with the ill-fated advocate having to do the advocacy by telephone. Now, that's actually an issue that might call into question whether each party had an equal opportunity to present their case. So, are virtual hearings a direct equivalent to physical hearings? Well, in my view, no, they're not, but equally, I'm not sure they should try to be. And in actual fact, virtual hearings probably bring with them some facilities that aren't available, some benefits, I should say, that aren't available in a physical hearing concept. But I would suggest that there are some important drawbacks in using a virtual hearing platform. And some of those might not always be immediately obvious. So, you know, a simple example. When I'm sitting as a member of a tribunal, I actually find it very helpful to spend time with my co-members. Now, that might only be over coffee breaks and lunch breaks, but it's useful to me to understand their mindsets, their concerns, and the like. And that type of time is just not replaced in the virtual world. Now, my greater concern probably comes from when I'm wearing my barrister's hat, and it is this. I don't think it's possible to advocate a case quite as well on a virtual hearing platform. And this is a view that's been expressed by some of my fellow advocates specialising in international arbitration. Now, granted, in some cases, the difference might be so small as to be imperceptible. But I do believe there are cases in which it could make a material difference. Now, a tribunal member in a recent virtual hearing had a tendency to lean back in his chair to the point that only the top of his head was visible to the camera. And that made it difficult, for example, to know when he'd finished reading the evidence so that I had called, so I knew I could move on. More generally, I find it difficult in virtual hearings when acting as a lead advocate to recognise when the tribunal has grasped a point and I should move on, or when a tribunal is against me on a point and just labouring it further might only serve to irritate the tribunal. Now, I also share the view of many advocates I've spoken to that controlling witnesses in a virtual setting is more difficult. And this impacts on important areas such as the extent to which witness evidence can be tested under cross-examination, and also on efficiency when it comes to a difficult witness, keeping them on point when answering the precise question put to them, rather than trying to present to the tribunal points he or she wants the tribunal to hear. Now, I have also noticed that some witnesses take a far more casual approach to giving evidence at virtual hearings, and that perhaps that's just a product of so many of us spending hours and hours on virtual hearing platforms each day. Whereas, of course, the witness stand in a physical hearing room serves as a stern reminder of the circumstances. And this is a point, in actual fact, the English courts are currently looking at. They're considering for court hearings using virtual hearing platforms for hearings outside of major cities. But one of the big concerns they have is that they're finding that participants, such as witnesses, do not conduct themselves in a manner suited to a hearing when appearing on a virtual platform. Now, I should stop here and say that we have a different approach in the common law and civil law backgrounds to hearings. And of course, I'm speaking in Qatar, I'm speaking to primarily a civil law audience. So it's probably important to touch on the distinctions here. Now, of course, civil law jurisdictions, hearings are quite often shorter than the common law equivalent. And more frequently, contemporaneous documents are preferred for establishing facts to witness evidence. And in fact, in some civil law jurisdictions, an employee of a party is not permitted to give evidence since they're deemed to be too partial. Now, the common law approach probably goes to the opposite extreme here. And some of the old school common law judges and arbitrators would be reluctant, for example, to believe that the sun rose on a certain morning unless they have witness testimony on that point. The common law approach, for example, of using witnesses to confirm contemporaneous documents will often seem bizarre to a common law practitioner, although I should say that's probably a decreasing practice even in the common law world. Now, drawing these two areas together, one of the commendable aspects about international arbitration is the progress it's made, and it continues to make, in finding an optimized middle path between, on one hand, a civil law approach, and on the other hand, that common law approach. Now, it may be that this progress results in less reliance on witness evidence. We've seen, for example, a paper recently by the ICC on the accuracy of fact witness memory in international arbitration. And papers and drives like that may lead to the decrease in the reliance on witness evidence. And even, again, going to the common law areas where witness evidence is more prevalent and cross-examination is more strongly relied upon, we're still seeing a withdrawal from the reliance on witness evidence. For example, if parties are appearing before the English commercial courts, they will need permission to file witness statements that exceed 30 pages in length. My opinion? Well, I believe that, yes, witness evidence is sometimes overused in domestic and international arbitration, but I believe that there are instances in which witness evidence, testimony, and cross-examination is essential. It's essential for getting to the facts. Now, I'm involved, for example, in a dispute at the moment in which a fundamental change to the project was instructed at a meeting. There are no minutes to the meeting. There's no documentary record. And it's entirely feasible that millions of dollars could turn on the witness evidence of one witness from each side. Now, in those circumstances, if the cross-examination at trial was hindered in any material way, it could give cause for concern over whether justice will be served. Now, even when there are contemporaneous documents, cross-examination can demonstrate that the documents are unreliable. And it's probably worth turning here to a common example I've seen in this region. And that is where you have an engineer on a construction project who has written letters to the contractor saying, "Dear contractor, you are responsible for delay. You're causing delay to this project." And one is quite often able in cross-examination to expose that that witness can only actually accurately testify to there having been slippage from the programme, and that the witness, when he was writing these letters, hasn't looked at the underlying causes of delay. And those could, for example, be late provision of design or delayed access, which are factors outside of the contractor's control. So we have these circumstances where there are contemporaneous documents, but relying on them without cross-examination could have a perverse influence on the resulting award. Now, it may be that the international arbitration community can navigate a sensible course towards some limitation of cross-examination with a view in increasing efficiency, but without impeding justified testing of witness evidence. But, an important but here, in my view, it's not appropriate to see important cross-examination that could influence an award being hindered because a virtual hearing was more convenient to some. And on that point, I should say, I do wonder whether the constraints on the ability to advocate a case in a desired manner are quite as obvious to people who solely sit as arbitrators. So I fear that there's a danger that arbitrators may lean towards using virtual hearings because of the convenience that comes with them. So what points should and should not influence the choice of the virtual hearing format? Well, ultimately the concern in arbitration is, of course, that the award is not enforceable. Now, given that a recalcitrant party will sometimes seek to have an award vacated on pretty much any grounds it can conjure, such issues as, for example, an advocate being impeded in presenting the case to its best visibility because they had to conduct advocacy by telephone. Issues such as the broadband connection of a key witness dropping out during cross-examination and disrupting the cross-examination. Issues such as an expert performing badly because his time zone meant that he was giving evidence until 3 a.m. in his local time. Those type of issues could furnish that recalcitrant party with additional grounds for arguing that they didn't receive a fair hearing. Now, I would go so far as saying that with every virtual hearing comes at least a small degree of increased risk as compared to a physical hearing. Now, I should qualify that by saying it is likely to take exceptional circumstances for the choice of a virtual hearing format to lead to having an award vacated. But if that does happen, the consequences are, of course, severe. Now, before getting into possible reasons that might weigh for and against, I should say, of course, that the choice of a virtual hearing or a physical hearing isn't black and white, and there are hybrid options in between that could deal with some of the potential issues. So I'll give a few examples of issues that, or points that might weigh in favour of holding a virtual hearing. And for me, the biggest one is both parties, or all parties, I should say, being in favour of having a virtual hearing. And I go so far here as saying that tribunals may actually choose in the future, and it may be advisable for tribunals to record the agreement of any parties in their award to help insulate against potential challenges. Another factor that might weigh in favour of a virtual hearing is the dispute being a low value one that doesn't include complicating factors, or indeed the dispute not involving extensive documentation. Now, a hearing being less contentious could favour a virtual hearing, and I think in the context of things like case management conferences, one would imagine that the default position, and probably quite appropriately, is for those to be held in the future on a virtual platform. Hearing participants being broadly spread in one country or across a number of countries is a factor that might influence the choice of a virtual hearing. But what could count against the choice of virtual hearings, and I'll come back to the point in a moment, is a broad span of time zones. Now, that a hearing is short could be an influential factor in choosing a virtual hearing format. But I would suggest that it's the most important thing here is the nature and the content of the hearing. And an interlocutory hearing that could be dispositive might not suit a virtual hearing format if either party has cause for apprehension. So those are just a few examples that one might consider in favour of a virtual hearing format. What about a few examples of factors that might weigh against? Well, one might be the importance of important witness evidence that requires detailed cross-examination on complex points. All of the parties being located in one country is a factor. Now, I think this is an important point in the context of domestic Qatari arbitration. If most or all of the parties are located here, there's perhaps an increased risk, even if it's small, in using virtual hearing format. But is there really going to be any cost saving realised as a result? You've got some low cost and very good hearing venues here, such as the QIC DRC venue and hearing rooms at the Qika building. Whereas to organise a virtual hearing, the parties have additional steps such as drafting and agreeing a virtual hearing protocol. They have to typically organise and pay for electronic presentation of evidence. There's typically set up and rehearsals of the hearings, and those rehearsals are very important, I should say. So that there's perhaps cost savings if all parties are local for it using a virtual hearing, using a physical hearing. Participants being spread across a broad range of time zones are a factor that's proving complicated and proving difficult when looking at virtual hearings. And I'd actually go so far here as suggesting that we might see parties in the future considering the location of an individual when looking to appoint experts or an arbitrator because of the impact that the time zone may have if a virtual hearing comes at the end of the arbitral proceedings. Other factors that might influence the choice of a physical hearing are the predictability and reliability of the domestic courts that might be used for enforcement of law. Are they pro-arbitration generally? Have they shown any inclination against virtual hearings? Then, of course, we have practical points to consider. So simple examples include whether key participants are located in zones where internet connections can be slow or unreliable. I've seen that happen in Lebanon, and of course there are other regions. Or people being located in regions where power supplies can be inconsistent. We've seen this in Africa. So that's probably my time used up. So I'll draw these threads together to form a conclusion. In my view, virtual hearings are an excellent tool, and I think they undoubtedly have a place in post-pandemic arbitration proceedings. But I caution against jumping into adopting a virtual hearing format without careful consideration of the vital factors and the additional risks that might arise. So, by way of Parthian shot, I suggest that the virtual hearing format should always be driven by what is most appropriate for the dispute, and never purely by what is convenient for just influential people. So on that note, I'll say thank you very much, and I'll hand back to Dr. Minas.
Thank you very much, Mr. Parker. Of course, we understand the challenges related to conducting a virtual hearing. And as you have rightly said, you have to study the circumstances of each case and to see how much it can be adapted to conduct and organize a virtual hearing. Nevertheless, in a recent study, and there was even a publication made in this concern, almost 75% of the pending arbitration cases in the world, especially during the pandemic time, have been conducted remotely. And I will say 60%, as per the study, are satisfied of this experience. So time will tell us if we'll go to reinforce and to put, I will say, more safeguards in order to conduct these virtual hearings to the benefit, to the interest of the parties, and also to the benefit of the justice itself, the arbitral justice, which is at the end the objective of all the participants in an arbitration. Thank you again very much for your thorough and deep presentation and the considerations you have put in relief. Well, now we are going to pass to the third speaker. We welcome Mrs. Pamela McDonald. Pamela McDonald is, until tonight, a senior associate, because starting from tomorrow morning, the 1st of April, she got a promotion and she's becoming a partner. So congratulations, Mrs. McDonald. Congratulations from all the participants, from all the speakers, from Kika. So I will say you are now a partner at Pinsent Masons in Qatar and a registered Kika arbitrator. Pamela is qualified in England and Wales, and she moved to Qatar in 2014. And she represents clients in dispute resolution and avoidance matters. Mrs. McDonald clients are in the infrastructure and energy sectors in the Middle East. Pamela has represented clients in cases including Hamad International Airport, various gas process facilities in Qatar, the metro project, and a power and water plant in Al-Waqra. Pamela is a board member of the Chartered Institute of Arbitrators Qatar branch and participates in various Qatar arbitration community initiatives to increase Qatar's profile as a seat of choice for Middle Eastern parties. Pamela McDonald, partner at Pinsent Masons, is going to present to us the following topic: recent trends influencing the arbitration industry in Qatar. The floor is yours.
Thank you. Thank you very much for that kind introduction. And I have to just correct you, it's the 1st of May, so I still have 1 more month to wait before I can reach the dizzy heights of partnership at Pinsent Masons, but thank you kindly. And thank you for having me today. It's an honour to be part of this distinguished panel. I'm going to try to cover a lot of topics today in 20 minutes. To give a flavour of some of the recent trends that we're seeing in Qatar. I'll probably not be able to do justice to all of them because of our time restraints, but at least the idea of this segment is to put these ideas on your radar, on the radar of the members of the arbitration community in Qatar tuned in today. So the first topic I want to mention is in relation to PPP and how it could influence our arbitration community in the future. We're all aware of the introduction of the PPP law in Qatar recently and the various projects which Ashghal are releasing to the market on a PPP model basis, which is of course commendable and progressive and beneficial for the Qatari economy. The Ashghal standard form contract contains only an optional arbitration agreement in it. And if it's an administrative contract, which is one involving a public company and it's a public benefit type project, then to invoke the optional arbitration agreement in that Ashghal form will require the consent of the Prime Minister or his delegate under the arbitration law of Qatar. Now, at the moment, what we're observing is that the PPP contracts being negotiated at the moment are adopting a traditional approach whereby Ashghal are suggesting disputes should be resolved by litigation through the Qatari courts. But the nature of the funding arrangement for PPP projects involving financial institutions, lenders consortiums and so on, who have skin in the game, so to speak, and are keen to have certainty as to the outcome of any disputes that might arise, may well mean that the optional arbitration agreement in the Ashghal contract is going to be used for these PPP projects. Time will tell. Now, of course, arbitration agreements in contracts predating 15 April 2017, when the arbitration law became effective, obviously don't make an election as to the competent court and the competent judge, and by default the general courts have jurisdiction, although parties might seek to agree something different through their terms of reference. The PPP project contracts that we might start to see enter the market, which contain arbitration agreements in them maybe, will have given consideration to the option of making that election as to the competent court and the competent judge for enforcement. Now, unfortunately, disputes on these mega projects that being let on a PPP model basis are inevitable in some ways, and that's because these are complex, major infrastructure projects that are being built, massive package of schools, water treatment plants, and so on and so forth. And naturally, they give rise to disputes. Now, if the contracts have arbitration agreements, in some ways that means that the release of PPP projects to the market could be a catalyst for the uptick or the increase in arbitration in Qatar in the near future, not just at main contract level, but also flowed down into the supply chains. And furthermore, they could be a catalyst for the Qatar international courts to have more cases which have an arbitral element to them if the election is made to use the Qatar international courts. And so that's just something that's on our radar at the moment. We're interested that we've seen the release of these PPP projects. Traditionally, those types of arrangements would adopt arbitration agreements. Time will tell whether that is invoked in these contracts. And if it is, then that's going to be really interesting for the arbitration community in Qatar. Now, the next little mini topic that I'm going to talk about today is the impact of the Singapore Mediation Convention on arbitration. So the tangible benefit, of course, of international arbitration as a system of resolving disputes is the international enforceability of the awards as a result of the New York Convention. And as we all know, the Singapore Mediation Convention was ratified by Qatar in March 2020, and it provides parties with better certainty as to the enforceability of settlement agreements resulting from a mediation. So what impact has or will the Qatari government's backing of this international convention have on the arbitral community in Qatar? And sometimes commentators and arbitration practitioners view arbitration and mediation as opponents, maybe. There might be a fear of arbitration losing its status as the most preferred form of ADR. Well, we know that Qatar's National Vision 2030 involves significant infrastructure spend in the coming years, and on that basis, it's likely the number of disputes will also increase, of course, at main contract level and supply chain level. And what parties want is for those disputes to be resolved without formal dispute resolution at all, arbitration or litigation. Mediation, which involves the parties reaching settlement with the help of an independent facilitator, is likely to become more prevalent in Qatar, and parties considering their tiered dispute resolution clauses and options are currently feeling very encouraged down the path of mediation because of the Singapore Mediation Convention. Clearly, mediation has the attention and support of the Qatari government, and the shift is revolutionary in some ways, but there's still some time needed for the Singapore Convention to really bed in to the legal systems of the various countries that have ratified it. It needs to come into domestic legislation, not just here in Qatar, which it has, I think, but also in the international countries where parties might seek enforcement of their settlement agreement resulting from a mediation which isn't being complied with. It also needs more signatories. There still isn't anywhere near the same number of country signatories to the Singapore Convention as there are to the New York Convention on enforcement of arbitral awards. But anyway, the logic and the attraction of mediation for parties is overwhelming. And so it's inevitable in some ways that it is going to become more prevalent. And that's not a bad thing. As members of the arbitral community, we tend to consider how our cases would play out differently if a mediated solution was adopted. We try to encourage cost efficiencies and so on. And although arbitration and mediation compete in the same conceptual space of ADR compared to litigation, the dynamic is actually mutualistic. It's not competitive. And the development of mediation as a form of ADR in Qatar isn't, I think, at arbitration's disadvantage. The two forms of ADR have different competitive advantages, and an increase in mediation would be of benefit to Qatari companies' acceptance of alternatives to courts generally. Something we might start to see on the journey towards all of that is the rise of quasi-ADR forms such as Med-Arb. That's essentially a process whereby the parties agree to mediate, but if they don't reach a decision between themselves, they delegate power to the mediator to make a decision. Now that process, in my experience, isn't as helpful at achieving a mediated outcome between the parties, because the parties often tend to start policing what they're saying in front of the mediator, and they might feel that they can't let their guard down and have a successful negotiation. So that might be a problem. It's also not the case that these type of settlement agreements that have been recorded as enforceable as an arbitral award at the outcome of a Med-Arb are within the scope of the Singapore Convention. Actually, they're carved out by Article 1.3b. So that's my views on trends we're observing and we might observe in the future as a result of the Singapore Convention. The next mini topic I'm touching on now is climate change. And I want to talk about climate change and the arbitration community in Qatar. Some that are tuned in today may be aware that the way lawyers and tribunals are practicing arbitration day to day is being put under a microscope by those who rightly advocate for practices which are the least harmful on the environment. In 2019, the campaign for greener arbitration was launched by a group of arbitration practitioners committed to achieving sustainable change in the way arbitrations are managed. And the campaign created something called the Green Pledge, which has been signed now by hundreds of law firms and independent practitioners and tribunals all around the world. And the pledge is essentially a commitment to practice arbitration in a way which minimises the carbon footprint of the case. The campaign's research found that, astonishingly, one arbitration can actually result in the loss of 20,000 trees when you take into account printing and air and road travel and the impact of that on carbon emissions, which I think is shameful. And I think we need to correct that as arbitration practitioners. So the next step for the campaign is to produce protocols containing more detail on how we can comply with the Green Pledge. And there was recently a series of roundtables across various jurisdictions, including the Middle East, which I and other members from Qatar and other Middle Eastern countries attended and contributed to in order to ensure that these protocols that are going to be released reflect our Middle Eastern realities. Those protocols are being refined following these roundtable sessions, and they're going to be released formally. And I really hope Qatari law firms, local and international, independent practitioners and tribunal members and institutions like Kika carefully review these protocols and consider adopting them to make sure that we're all practicing arbitration in a way which is the least harmful to the environment. Because, of course, the topic of climate change is not going away. And that adjustment to our behaviour in Qatar is also consistent with the Qatar National Vision's fourth pillar, which relates to its commitment to environmental development. Finally, on climate change, I'll just say one more thing. I've spoken about how we can adopt new practices as members of the arbitration community, but of course it's also worth mentioning there's a growing number of global cases arising out of climate change related issues, and that includes arbitration as well as litigation, and in particular bilateral investment treaty arbitrations. Now, the next conference of the parties in Glasgow, called COP26, will be the 5-year milestone from when the Paris Agreement was signed. And members of the arbitration community will be watching that COP26 with interest to see if the arbitration annex, which has been discussed by the parties but not yet activated, is entered into this year. If it is activated, then arbitration will become more widely used as a means of resolving climate change related disputes, and arbitration practitioners in Qatar may be interested to observe the trends emanating from that. Now, the last mini topic in this segment that I'm going to cover is something which I think is important to keep on our agendas as members of the international arbitration community in Qatar, and that's gender diversity of arbitral tribunals. Now, we all know, of course, that diversity is a strength, and it's accepted that important decisions are better taken with the benefit of diverse insights. So, of course, arbitration decisions should benefit from that diversity of thought. In 2020, the International Council for Commercial Arbitration, ICA, released a report of the cross-institutional task force, and it was a massive number of institutions came together to deliver this report on gender diversity in arbitral appointments and proceedings. It's report number 8 and it's available online. The task force commitment is to promote equal representation of women in international arbitration. And we're certainly seeing some better diversity of lawyers representing parties in arbitrations. And that's due, of course, in part to law firms having signed up to the Equal Representation in Arbitration Pledge, which was drawn up in 2015. Again, that's available online. And also law firms getting competitive in a really good way and introducing quota targets to have more gender balanced partnerships. And so that's leading to an increase in female counsel representing parties in arbitrations. And of course, over time, some of those lawyers will be appointed as arbitrators, and the gender balance of tribunals will happen organically in that way. But the data collected by this task force shows that since 2015, the proportion of female arbitrators has almost doubled from just 12% in 2015 to 21.3% in 2019. So that's astonishing and that's good. That's reflected in the caseload that's reported of institutions. But there's still a lot to be done. And so in this interim period where we're on the journey, there's a movement amongst practitioners, including at Pinsent Masons and in other firms in Qatar as well, to ensure that we're suggesting potential tribunal members as candidates who are women. We always try to include at least one woman arbitrator as an option for our clients to consider. And there are tools available to help us on this journey. For example, the Arbitral Women Database is helpful. That endeavours to create a list of women arbitrators, and you can distill that by jurisdiction. You can see who's listed on there under Qatar actually, and you can see their credentials and so on. And the availability of these types of tools and the knowledge of this movement is important to us in Qatar. And when we suggest the shortlist of our party nominated arbitrators to our clients, we must make sure that there is at least one woman on the list to ensure there's that gender balance for all of the reasons that we know about diversity. So there's a shift starting, in fact, it's already started, towards better balance of gender diversity on tribunal panels globally. And I'm sure that's a trend that we're likely to see in Qatar too. I'm certainly advocating it, and I know others in Qatar are too. But it's subject to the demands of the parties and their lawyers, who ought to together be demanding better balance. And with that, I'll close off and hand back to Dr. Minas. Thank you very much.
Thank you very much, Mrs. McDonald, for this beautiful promenade through these many topics you have selected nicely. And in fact, each topic or each mini topic can be the subject of a webinar. So we have to think about this, because all the topics you have presented are very important. Of course, each one according to, again, the circumstances we are going through. PPP for Qatar looks, of course, something very important. So what you have said also about the public-private partnership projects for Qatar is important. I had not yet the chance to read, but I will invite all the participants to go to the website of the United Nations Commission for the International Trade Law, the UNCITRAL, where they have recently published a guidebook about how to draft the PPP contracts, including also the dispute resolution clause, and talking also about the balance, I would say, of powers between the state on one side and the partner, the investor on the other side, and how to find always solutions to the benefit of both parties. Well, thank you again. And now we are going to pass to the following speaker. Mr. Thomas Williams. Thomas is an English qualified barrister and partner at Sultan Al Abdullah and Partners law firm, where he is the head of arbitration. As an experienced advocate, he has appeared frequently in the English High Court, including the Commercial Court, and Court of Appeal, as well as in arbitrations under the major institutional rules and ad hoc arbitrations. He has appeared before the Qatar International Court and sits on the user committee. His main sector expertise is construction and engineering, energy, oil and gas, banking and financial services, and professional negligence. He sits as an arbitrator and is a member of the panel of arbitrators of the LCIA, of the SCC, of the MCIA, and of Kika. He has been appointed to conduct an expert determination under Qatari law. Mr. Wilson is going to present also a very important topic. It's about the advance on costs in arbitration, reimbursement of substituted payments. Mr. Thomas, the floor is yours.
Thank you very much for that generous introduction, and it's a great pleasure to be taking part in this webinar. Now, a respondent's refusal to pay its share of the advance on costs is an increasing trend in international arbitration. And it might be that that refusal is as a result of genuine economic constraints, but more often than not, it appears to be a tactical ploy designed to scupper the claimant in proceeding with its claim. And in those circumstances, a claimant will have no alternative to keep the arbitration alive, but to make a substituted payment in respect to the respondent's share of the advance, and then bring a claim before the tribunal for immediate reimbursement by way of an award or procedural order before the final award is handed down and costs are finally fixed. Now, I'm going to be looking at this issue from the perspective of various arbitral institutions, including Kika. I'm going to be looking at whether the claim is procedural or substantive and the consequences of that distinction for enforcement. And then I will turn to a recent decision in a Doha-seated ICC arbitration where this issue was considered. Now, just starting with the ICC rules. Under the 2017 and 2021 ICC rules, the regime governing the costs of arbitration is set out in Articles 37 and 38 and Appendix 3, which are materially identical in each version. Now, Article 37 prescribes the process by which the advance on costs is fixed. Article 38 governs the tribunal's decision as to the costs of arbitration. And Appendix 3 covers ancillary procedural matters and the rates at which the costs of arbitration are computed. Now, generally, the ICC court fixes a provisional advance on costs, which is intended to cover the likely administrative costs of the ICC and the tribunal fees until the terms of reference are drawn up. This provisional advance is by default paid by the claimant. And thereafter, the ICC court decides the total advance on costs referable to the aggregate quantum of the parties' claims and counterclaims. Now, as is commonplace under leading arbitral institutional rules, the parties are expected equally to share the advance on costs, and the provisional advance is calculated towards the claimant's share to be included. Now, while the ICC court has the power to fix separate advances on costs for claims and counterclaims, it only tends to do so if there's a significant difference in their quantum. And otherwise, a party bringing a counterclaim of a considerably lower value, or indeed a claim of a considerably lower value, would be burdened unfairly. Now, since the rule is that the parties are required equally to share the advance on costs, there is a risk that the respondent may fail to pay its share, as I've said. Now, in that situation, Article 37(5) of the ICC rules permits a party, normally the claimant, to make a substituted payment on behalf of the defaulting party. Now, the consequences for the defaulting party are not spelled out in the ICC rules, and it's noticeable that the ICC court does not have the power to oblige a defaulting party to pay its share. Now, notwithstanding this, if the advance on costs is not fully paid up by the parties, the tribunal can suspend its work, and the ICC court may consider that the claims are withdrawn. Now, as you'll see, a defaulting party can therefore frustrate the process, so the claimant will have no choice but to make a substituted payment. Turning now to the Kika rules, Articles 43 to 48 deal with arbitration costs, and as with the ICC rules, the Kika rules also prescribe a non-refundable registration fee and authorize the Kika Secretariat to fix the advance on costs referable to the quantum in dispute. Now, interestingly, the Kika rules go one step further than the ICC rules, and the case file is not transmitted by the Kika Secretariat to the tribunal if the advance is not paid. And the provision that deals with that is Article 43(7). Now, under Article 48(2) of the Kika rules, a party is allowed to pay the defaulting party's share, and failing such a payment, the arbitration may be suspended or terminated. But unlike under the ICC rules, there is no provision in the Kika rules which directs the tribunal not to proceed with adjudicating on a counterclaim in respect of which the costs are not paid. But as a matter of practice, Kika does not allow a counterclaim to proceed if the respondent has not paid its share of the arbitration costs. Now, this ensures that the proceedings are efficiently conducted, open quotes, so as to avoid unnecessary delay and expenses that are likely to increase the costs of arbitration in an unjustified manner, close quotes. And that provision is Article 18(7) of the Kika rules. Coming now to other institutional rules. There are other such rules which deal expressly with the substituted payment of the advance. For example, the LCIA rules and the SIAC rules give the tribunal discretion to order such reimbursement by way of a partial award or a procedural order. And I will discuss the significance of the form of the tribunal's decision later in this presentation. Articles 24(4) and 24(5) of the LCI rules entitle the claimant to recover the substituted payment as a debt from the defaulting respondent. And likewise, Article 27(g) of the SIAC rules authorizes the tribunal to issue, open quotes, an order or award for the reimbursement of unpaid deposits towards the costs of the arbitration, close quotes. The arbitration rules of the Mumbai Centre for International Arbitration adopt what might be considered a hybrid approach to the issue. Article 33(5) of the MCI rules provides as follows. Parties are jointly and severally liable for the costs of the arbitration. Any party is free to pay the whole of the deposits for costs of the arbitration in respect of the claim or the counterclaim should the other party fail to pay its share. The tribunal or the registrar may suspend its work in whole or in part should the advances or deposits directed under this rule remain either wholly or in part unpaid. On the application of a party, the tribunal may issue an award for unpaid deposits towards the costs of the arbitration pursuant to Rule 29C. So the MCIA rules reflect the approach of the ICC rules and the SIAC rules by allowing the institution to suspend or terminate its services if the advance on costs is not paid, whilst following the approach of the LCIA rules in empowering a tribunal to hand down an award in respect of an unpaid advance. Now, if a party is compelled to make a substituted payment of the advance, the issue then arises as to the legal basis of that claim or entitlement. Now, according to Darwaze and Greenberg, writing in the Journal of International Arbitration, there are two opposing views. Either the duty to pay the advance on costs is contractual, substantive, or it's a procedural issue, a procedural obligation owed by the parties to the arbitral institution. And if it's the former, then the claim is based on breach of contract. And if it's the latter, the claim is brought for a breach of a procedural obligation. Now, I'm of the view, for what it's worth, that the obligation to pay the advance on costs is a contractual obligation as between the parties. Further to the arbitration agreement, the parties contractually agree to comply with the applicable arbitral rules, including the obligation to pay their respective shares of the arbitral institution's advance on costs. So a respondent's failure to pay its share is a breach of the arbitration agreement. And the sum paid by a claimant as a substituted payment of the advance constitutes the claimant's loss, because but for the respondent's breach, the claimant would not have had to have paid the substituted sum. And this view is supported by the writings of many international arbitration practitioners and scholars. For example, Fadlallah states that, open quotes, the party's obligation under Article 37.2 of the ICC rules is not just an obligation towards the ICC, it forms part of the arbitration agreement. The parties cannot agree to refer their dispute to arbitration and at the same time retain the freedom not to do whatever needs to be done to make arbitration possible, as they would then be in breach of their obligation to act in good faith. And likewise, Craig, Park, and Paulson say that, open quotes, the defaulting party's refusal to pay its advance would ordinarily constitute a breach of contract, since by agreeing to arbitration under the ICC rules, it has agreed to respect its provisions regarding advance on costs, close quotes. And it seems that tribunals tend to follow this approach. In ICC case number 13139 of 2004, the tribunal held as follows. In the view of the arbitral tribunal, the agreement to arbitrate is a separate contract which differs in its nature from the contract on the merits, inasmuch as it is a contract of a procedural nature, but it is a contract nevertheless, giving rise to a procedural obligation to provide the advance on costs. The respondent accordingly had an obligation to make the advance unless it is excused from this. As a matter of legal doctrine, the arbitral tribunal finds the conclusion inescapable that if a contractual obligation, even if it is a procedural contractual obligation, has been breached, it has jurisdiction to issue immediately a partial award in favour of the party that substituted itself for the defaulting party. And similarly, in ICC case number 13290 of 2008, the tribunal noted that, open quotes, the claimant was effectively forced to pay the respondent's share of the advance on costs so that the arbitration would proceed, close quotes, and found that the amount paid by the claimant equated to the damage that it suffered as a result of the respondent's breach of contract. Recently, a tribunal constituted under the arbitration rules of the Arbitral Institute of the Finland Chamber of Commerce followed this approach, and it said as follows. Since the parties have adopted the FIA rules by reference in the arbitration clause, they have undertaken to comply with the obligation to pay half of the advance on costs. The prevailing doctrine affirms the contractual nature of such provision. The matter in dispute is thus a matter of substance on which the arbitral tribunal may render a decision regarding the reimbursement of the advance on costs paid on behalf of another party by way of a separate award. Now, reimbursement of substituted payments is more straightforward in arbitrations governed by arbitral rules which explicitly permit the tribunal to grant such relief. For this reason, LCIA tribunals are likely to render partial awards in this regard at the request of the non-defaulting party. Now, a minority of practitioners and scholars and tribunals consider that the obligation to pay the share of the advance on costs is a procedural matter, and that a party's default in this regard should be dealt with by way of a procedural order. Now, supporters of this procedural approach are further divided into those who believe that immediate reimbursement is possible, and those who state that the tribunal cannot take any such course because it can only decide which party must ultimately bear the arbitration costs. For example, a tribunal in an arbitration conducted under the Vienna rules held that, open quotes, according to the structure of the Vienna rules, fixing the costs of arbitration was a purely administrative matter. The arbitral tribunal, however, had to determine the costs of the parties and to state which party was to bear the costs of proceedings. And by adopting the Vienna rules, the parties had agreed that the arbitration costs would be fixed by the Secretary General. There was no express agreement authorizing the tribunal to order reimbursement of a substituted payment of the advance on costs, and accordingly, it had no power to do so. The basis of the party's obligation to pay the advance on costs should determine whether the tribunal's decision is by way of an award or procedural order. Now, this is significant because the form of decisions has an implication for its enforceability. Now, I believe that a tribunal's decision to order reimbursement should take the form of a partial award rather than a procedural order, if it decides that the obligation to pay the advance on costs is contractual. This is because the tribunal will be ruling on the parties' substantive rights and liabilities, and such a decision requires a detailed level of reasoning. Now, a partial award can, of course, be enforced under the New York Convention or any applicable international treaty which recognizes the enforcement of international arbitral awards. On the other hand, if the tribunal considers the matter to be merely procedural, it would be more appropriate for it to direct reimbursement by way of a procedural order. The issues in point would not be substantive, and whilst the tribunal would need to explain the basis of decision, it wouldn't be required to give the sort of detailed reasoning which is expected in an arbitral award. Now, this will often present enforcement issues if the order isn't satisfied, because there are no international conventions or treaties that govern the recognition or enforcement of procedural orders, and enforcement has therefore to be pursued in accordance with local arbitration and procedural laws. And in Qatar, the statutory regime provides for enforcement only of arbitral awards. And Chapter 7, Article 34.3 of the arbitration law makes that clear. So in my view, procedural orders are not enforceable in this jurisdiction. So in order to avoid procedural problems, if a tribunal considers that the obligation to pay the advance on costs is contractual, it should be encouraged to do so by way of reimbursement, by way of a partial award. Now, to place what I've just said into a practical context, I'm now going to consider a decision of a tribunal recently in a Doha-seated ICC arbitration where this issue was very much in point. The Qatari party, which was the claimant, initiated an arbitration against an Indian party, the respondent, for the recovery of outstanding payments due under a Qatari law-governed contract. And during the currency of the arbitration, the respondent was placed into an insolvency process in India by virtue of an order of the National Company Law Tribunal under the Indian Insolvency and Bankruptcy Code, or the IBC. Now, as a result of that order, insolvency proceedings were formally commenced, and this led to the suspension of the respondent's board of directors, and the respondent was put under the control of a resolution professional, as that individual is called under the IBC. And there was then an imposition of a moratorium. Now, the respondent, perhaps predictably, failed to pay its share of the advance on costs. And so the claimant then made a substituted payment and sought from the tribunal the reimbursement of that substituted payment in the form of a partial award, or in the alternative, a procedural order. Now, in respect of its request for a partial award, the claimant sought the relief as damages for breach of contract, or alternatively by way of specific performance under the Civil Code. The claimant contended that the parties had contractually agreed under the subcontracts to comply with the ICC rules, including the obligation to pay the advance on costs under 37.2 equally. So the argument went, the failure of the respondent to pay its advance on costs constituted a breach of contract. And in support of that submission, the claimant relied on the writings of the various practitioners and the decisions of the tribunals to which I have already referred. Now, in the alternative to seeking damages for breach of contract, the claimant applied for specific performance by way of a partial award. And for this relief, the claimant relied on Article 2411 of the Civil Code, which provides that, open quotes, if the debtor does not execute his obligation voluntarily, he is compelled to do so, close quotes. The claimant also argued that the respondent had a duty of good faith under the Civil Code in respect of its contractual obligations. And we all know the genesis of that obligation. It's Article 1721, which provides a contract must be executed in accordance with its contents and by a method that is in accord with the requirements of good faith. So essentially, the claimant's case was that the respondent had to honour both the letter and the spirit of the arbitration agreement in keeping with principles of honesty and fair dealing, and consistent with such a duty. Not only was the respondent required to pay its fair share of the advance on costs, which was 50% of it, but it was also obliged to effect reimbursement if the claimant made a substitute payment on its behalf. In the alternative to a partial award, the claimant applied for a provisional measure under Article 17 of the Qatari arbitration law, ordering the respondent to make reimbursement. And to meet the legal test prescribed in that article, which requires a risk to the applicant of irreparable harm, the claimant relied on the respondent's insolvency in India. Essentially, the argument went that because the respondent was insolvent, if matters were left to the end of the arbitration and that the costs were dealt with finally and an award rendered, by then it would be too late. The claimant would simply be an unsecured creditor and would get nothing by way of recovery in the insolvency process. Now, the tribunal held that by referring to the ICC rules in the arbitration agreement, the parties agreed to be bound by those rules in a manner akin to any other contractual obligation. And the tribunal, interestingly, disavowed the procedural approach, and it held that the contractual force of the parties' obligation to pay the advance could not be undermined by the fact that the ICC rules prescribe a procedural remedy in case of default. And so the tribunal held that the failure to pay the advance was a breach of contract and issued a partial award accordingly. So just to draw things to a conclusion, in my view, it's preferable for arbitration rules explicitly to authorize a tribunal to order immediate reimbursement of the substituted payment of the advance on costs. In this way, a non-defaulting party has a clear and effective remedy. And arbitral institutions whose rules do not make such provision should consider revising their rules accordingly. But in arbitration agreements or arbitrations governed by institutional rules which are silent on this issue, a non-defaulting party should seek reimbursement on the basis of a breach of the defaulting party's contractual obligation to pay its share of the advance. And a tribunal is likely to assume jurisdiction to decide claims arising out of non-payment of the advance on costs and render a partial award. And in those circumstances, the partial award can be enforced under the New York Convention. Thank you very much.
Thank you very much, Mr. Thomas Williams, for this very important also topics that you have chosen for today. And I understand that in the big arbitrations, the fees are representing a substantial amount. And of course, sometimes in difficult economic period, it's a real burden for the claimant, particularly after having paid his share, to pay also the share of the respondent and to face the risk that this respondent may go under insolvency or goes also under difficulty of payment. So this gives us a lot of food for thought, especially also what you have suggested, that there may be a kind of immediate order from the tribunal to pay for these, I would say, delayed fees, or the recalcitrant party who has objected, or he has put some, I would say, resistance to pay these arbitration fees. I liked also very much the idea that this is a breach of the contract and that you are asking for specific performance according to the applicable law, and the tribunal may immediately issue a partial award or an order that will be, of course, binding on the respondent.
I don't mean to interrupt, but just as a follow-up of what Thomas said, we do have a ruling from the appeal court that procedural orders are not enforceable, and that parties have to wait until a final award is issued before referring matters that were in the procedural order to the competent court. Just this was not in my presentation, but now that it was raised. So there is a court ruling on the matter.
So if I can combine both ideas, I would say that we shall recommend to the arbitral tribunal in this case to issue a partial award rather than a procedural order.
Yes, procedural orders are not considered as judgments per se. So this is the main reason.
Yes, yes. And of course, the arbitral tribunal is going also to take the attitude of the parties in consideration at the moment of rendering the final award. All right, so can we now pass to our next speaker, who has been very patient with us because he has been listening to all what we have said. So we have the pleasure to welcome Mr. Mathieu Faupin. Mathieu Faupin is a senior legal consultant and deputy chairman for international relations at Al Sulaiti law firm in Doha, Qatar. He holds a master's degree in economic law from the French Université de Reims, Champagne-Ardenne, and a master's degree in public diplomacy and international relations from the University of Southern California. Mathieu's practice focuses on commercial, corporate, and business law matters. Prior to joining a Sulaiti law firm, Mr. Faupin worked in the United States in the field of oil and gas. Mathieu has taught law at Université Reims Champagne-Ardenne and taught international relations at the University of Southern California. Today, Mathieu is going to talk to us about the enforcement or the possibility of enforcing a foreign judgment in Qatar and how arbitration can fill the gap left by the absence of a bilateral convention. Mr. Faupin, the floor is yours.
Thank you very much, Dr. Minas. Thank you also to Thomas, because he's making the perfect transition, talking about ending his presentation by talking about the New York Convention. I am going to talk about it in a while. I'm trying to share my screen. Let me do that now. Here it is. All right. All right. So I am going to talk about the enforcement of foreign judgments and how the arbitration can fill in the gap left by the lack of bilateral convention. I might be given the impression that I'm going back to basics during this presentation, but we are actually handling a case where we are facing obstacles due to the lack of bilateral conventions when we are asking to execute, to enforce a foreign judgment. Here are the contents of my presentation. So I'm going to start by giving you a background of that specific case. We are going to explain you the obstacles that we are facing while enforcing a foreign judgment, actually a French judgment, in the absence of bilateral convention, a bilateral convention between France and Qatar. And I'm going to talk about the supplementary role of arbitration in such an issue, and I'm going to focus on the success, I should say, of the New York Convention of 1958. So here's quickly the background of that case. A French party and a Qatari party signed a contract governed by French law with jurisdiction of the French courts. A dispute arose and it was solved in front of the French commercial courts, and it was settled in favor of the French party. So we were asked at that part to enforce that judgment here in Qatar against the Qatari party. That's not an easy task. There is no bilateral convention to facilitate that reciprocal enforcement of civil or commercial judgments between France and Qatar, unlike the bilateral convention existing or executing between France and the UAE in 1991. That means almost 20 years ago. So here are the obstacles. The enforcement procedure must be in line with both enforcement procedures. And the French law is actually very detailed when it comes to that enforcement procedure. It starts, actually, the main issue starts with the notification of the judgment issued in France, which in such case must be done through the diplomatic channel. This means that the French embassy has to play a role and must ask the Qatari authorities to notify the Qatari citizen. The French authority and the French embassy cannot do any direct notification to the Qatari party. The French law says, or provide for the following structure, scheme. It starts with a belief. We have in France a belief system or profession, people that are in charge of notifying decisions, but also people that are in charge of coming and doing seizures, saving and your assets if you don't pay your debts and your other taxes. This is usually a profession which is not very loved, even hated more than lawyers, I should say. So that bailiff should send the decision to the public prosecutor in France, who has to transmit it to the Ministry of Justice, who has to transmit it to the Ministry of Foreign Affairs. The Ministry of Foreign Affairs has to send it to the French embassy. The French embassy has to send it to the Foreign Ministry of Foreign Affairs. The Ministry of Foreign Affairs has to send it to the local Ministry of Justice, and the Ministry of Justice has to send it to the competent authority to notify it to the Qatari entity, because that was so done involving a Qatari entity. But in the absence of a bilateral convention, this is just a mere act of courtesy. So that means that when France asks Qatar or the Qatari authorities to notify a decision issued in France, France is just asking an act of courtesy, which can be declined. So this is where arbitration plays an interesting supplementary role. Arbitration, I don't know if it's very necessary to say it, but it is usually praised for its speedy resolution, its confidentiality, the flexibility of its procedure, and the possibility for the party to choose their judge. The cost, usually more effective than a long court procedure, the expertise of the arbitrators, but the absence of a bilateral convention should encourage the parties to resort to arbitration, because comes in play a very interesting and very successful convention on the enforcement of foreign awards, is the New York Convention of 1958. The New York Convention allows courts of contracting states and obliges the courts of contracting states to recognize and enforce arbitration awards that are rendered in other contracting states of the convention. It's a very successful convention. It is, as of today, 168 countries have signed or executed this the convention. It's a fundamental. It has become a very fundamental instrument for international arbitration, for the promotion of arbitration worldwide. Now, talking about Qatar, and I would like to thank Claudia El Hage for sharing this decision with me recently. A decision issued by the Court of Cassation of Qatar in 2016 said that two important things. That first of all, that the enforcement of foreign awards is possible as long as the application for recognition and enforcement is in line with the provision of the New York Convention, and that no other conditions are necessary. It also says one thing. It says that the New York Convention is now fully part of Qatar laws. To conclude, should we advise in similar issue France and Qatar to execute a bilateral convention? I would say it's always better to fill in the gap, especially that arbitration is not always recommended. We know that when a matter is complicated, but the amount at stake is modest, arbitration might not be the preferred way to settle the dispute. But again, going back to basics, it is certainly advised to seek for the advice of lawyers and experts in the field. And if in the absence of a bilateral convention, the parties should definitely resort to arbitration for the resolution of their dispute. Thank you very much for your attention.
Thank you, Mr. Faupin, for this nice presentation. Of course, we understand where the challenge is, but let me tell you something. If the matter in dispute is not arbitrable, so there will not be an application to the New York Convention, it's still the same problem. It means that diplomatically, I think the two states, either Qatar and France, or France with another country, or Qatar with a third country, need, of course, to exert their efforts in order to conclude such bilateral conventions. Let me add also something. You know that between the Arab countries, we have a regional convention, the Riyadh Convention, for the enforcement of the judgments coming from the Arab countries. Some time ago, I tried to make a research about if there are any judgments where the judges have applied the provisions of this convention. Unfortunately, the number was very small, less than 5, from all the Arab countries' tribunals or courts. So this needs, of course, a lot of effort in order that we put forward these conventions, because these conventions have been signed, they are supposedly put into application, but we need a kind of will by the judiciary corps in each state in order to say these are the provisions, and they are, I would say, integrated into the national laws of each state, and therefore they should be a priori applicable each time that the conditions of the application of the convention are united or are present. Well, now that we have finished by having these interesting topics, I think we have some time, maybe 20 minutes, 30 minutes, we'll see, in order to answer to a few questions. We have received some questions. I don't know if the speakers can see the questions which are addressed to them. Yes? No, you don't see them?
I see the questions. Some have the name of the speakers, some don't. So
okay. So if you like, because you have been the first speaker, do you like to pick one or two questions to answer to them?
Yeah, the first question is from Ms. Lama Bakroon. She's asking if a QFC registered international law firm, if it can represent local entities in a Qatar-seated arbitration, regardless of the institutional rules agreed upon by the parties. And she seems to be insinuating to Kika, or she's mentioning Kika. Based on the appeal court ruling that you saw during my presentation, it seems that the court don't consider this as a matter of public policy. Now, again, this is the single judgment that I have seen. I have not seen others. Now, I would presume and assume that because it's the same division, they will be consistent in their position. However, the previous interpretation was that because of the provisions of Article 3 of the advocacy law, where arbitration is cited specifically in there as to be exercised by Qatari lawyers or lawyers who are qualified under the advocacy law, the interpretation was that this should be a matter of public policy, and therefore any arbitration where the parties are represented, have a legal representation, there should be a Qatari office assisting them or co-counseling with them. It seems that this is no longer the position taken, or it's not the position taken by the court, because I have not seen previous decisions in that regard under the previous law. It doesn't mean that they don't exist, but all I'm saying is that I have not seen them. It was an interpretation. So currently this is a position, yes, QFC firms can appear without Qatari counsel. The second question that I saw that was specifically addressed to me from Mr. Nader Ibrahim. He's saying, I have noticed that some Qatari appeal court decisions accept competence in appointing arbitrators, regardless of the place of arbitration, even when it is outside Qatar. What are your views on this sort of extraterritorial competence claimed by Qatari courts? This would lead one day to conflict of jurisdictions. And does the Qatari Arbitration Act need update in this regard? Actually, I cannot opine unless I see the actual judgment, because the facts seem a bit not, I don't know. Usually, no, the court where the arbitration is seated would be the competent one. So if it's outside Qatar, it would be the court as per the law in that particular jurisdiction. Now, what has happened in this particular case, we need to know more of the facts. But it is unusual, this I can say.
But if I may ask or add a detail, you know that according to the scope of application of the Qatari arbitration law, which is a procedural law, the parties may choose to have the seat of arbitration outside Qatar. Nevertheless, they are going to apply the provisions of the Qatari arbitration law.
It could be, but based on what the question says, I did not read these facts. So this is what I'm saying. We need to see what the situation was to see if yes or no, the courts in Qatar were competent to look into the matter or not.
All right, so Mr. Parker, I think there are also questions addressed to you. Unfortunately, there is one question in Arabic, but then there is another question, I think, in English. So maybe we'll start by the one in English, and then we shall try to find for you a translation for the Arabic one.
Yes, thank you. It will certainly be easier for me to start with the one in English. So there's actually a couple of questions in English. So the first of those is, do you think that what we call a neutral hearing assistant would be a must in cross-examination? Now, I hope I've understood the question correctly here, because there's various different terminologies used. But sometimes when parties are using a virtual hearing platform, they will choose to use Zoom, Microsoft Teams, or whatever it is, and they control that themselves. But there's another option whereby you use a third-party specialist host, like the likes of IAC, Lloyd Michaud have an offering, and there are many others out there in the market. I'm not here to promote any of them. But if you're using their services, they will do some very helpful things, I find. So they will control who is shown on this screen at any one time. So, for example, they might control it so that only counsel, the tribunal, and the witness or expert giving testimony are shown on screen. And you don't have a cluttered screen. And they move all the other participants to what they call the back of the room. And they can bring witnesses forward as required, and various other things. Now, that technical assistant, or I think this is what we're referring to here as a neutral hearing assistant, can perform other roles. And those are things such as dealing with technical difficulties. And likewise, these firms, these service providers, will often also go through the test protocols, help with equipment and so on beforehand. And a couple I've had experience with have found where somebody's had, for example, a unreliable internet connection, and they've shipped to them a satellite broadband device as a backup, so that you avoid issues such as an expert or a witness dropping out during cross-examination. Now, in my view, if the cost of what I call a hosted platform, where you have a technical assistant, is generally, in the context of domestic or international arbitration, very cost effective. I think this is a useful tool to be using to minimize issues that can arise, and my view is it's worthwhile generally. There is then a second question I can see here, which is regarding the virtual hearing protocol. Should it be left to the tribunal to draft, or is it better to have a uniform template adopted by the centre? Now, I don't think there's a one answer that fits all here, but in line with the points I was making in my talk, what I do think is very important is that it needs to be tailored to the dispute. Now, there are some very good virtual hearing protocols out there, and I think it's certainly beneficial to take an appropriate one as a starting point. And where the arbitral tribunal in question, if there is one, has a protocol that's suitable, then I certainly say that should be the starting point. What I've seen as being fairly good practice is the parties then looking at the protocol, discussing together between them adaptations that they think should be made for the specific dispute, and then that being put to the tribunal. And the tribunal may also have their own suggestions. And in one hearing I had, we then concluded with a short, I think it was a 2-hour conference to discuss a couple of issues. But I think so. The short answer is I'd certainly suggest using one of the templates out there as a starting point, because people have thought through all the issues, but do adapt it to suit the specific issues and the dispute in question. And those are the only questions I can see in English. So happy to stop there, or if there is anything else, I can pick that up.
The question in Arabic, I have read it and I can translate it in few words. The question is regarding how much the arbitral tribunal, in the case of ordering a virtual hearing, although the objection of one party to a non-physical hearing can be or can have an impact in a recourse to set aside the award later on?
Yeah, that's a very good question, and that's really the thrust of the issue around the virtual hearing. So, I mean, I would separate out here that what my talk focused on is what happens after the pandemic, because in some senses now there's not much option other than to use a virtual hearing. So we have the added burden of, in some cases, the only way we can proceed expeditiously is through a virtual hearing. But if we move this on to after the pandemic, when physical hearings are very easy to conduct again, if one party is strongly objecting to the use of a virtual hearing, is that a problem? Well, maybe it could be. And it's really going to depend on whether there's any justification for those objections. Because you may, of course, just have a recalcitrant party simply trying, and often the case with the respondent, simply trying to stop the proceedings rolling on and sitting and trying to throw spanners in the works. And it may be that there's actually a virtual hearing is very well suited and very appropriate, and they are really just trying to stop the progress of the arbitration. And in that case, I'd hope that it should not be a problem if one party objects. I'd hope that shouldn't then lead to problems with enforcement, unless, of course, something unexpected comes up in the hearing, like there are severe problems with witnesses' connections and the evidence just isn't presented well. But putting those exceptions to one side, the issue will probably come where a party has justification for raising an objection. They are saying with good reason, look, this just is not appropriate for a virtual hearing. And in those circumstances, I think that would be difficult to argue now because of the pandemic, but afterwards, when physical hearings are an option, if somebody has a very good reason for objecting to virtual hearings, I'd suggest those objections should be listened to carefully.
Thank you very much.
Actually, if I may add something on the side, the QFC courts are conducting all their hearings virtually. This has started since last April or March, I can't remember exactly, but around that date in 2020. And from what we understood, that the court is likely to hold all the hearings virtually. Even the state court's hearing, the criminal court did hold a virtual hearing. So I think that the future, this was something provoked by COVID-19, but the future could be that the virtual hearings would become, if not by default, but something that is within the normal procedures.
Thank you. So now it's the turn of Mrs. McDonald to pick up some of the questions addressed to her and to answer them, please.
No problem. I've seen one question, which is regarding the introduction of dispute adjudication advisory boards, DAAB, from the start in contracts in Qatar, and also whether there's any future for adjudication in Qatar. And just picking up the point about DABs, I am a big advocate of DABs, and I've seen them used very well in other jurisdictions. You can hardly pick up a contract in Africa that doesn't have a DAB, actually, and it's used to good effect. Obviously, it's highly used in Europe and other jurisdictions. It's rarely used in the Middle East. In fact, I've only ever heard of one contract which had a dispute advisory board in it from day one. And I think it was ad hoc. And there's probably a couple of reasons for that. The first is cost, and the second is control. And if it's not in the main contract, if the queue companies aren't willing to include it for cost and control reasons, then it's highly unlikely to have flowed down into the subcontracts, unless you've got two sophisticated, probably international parties who completely understand that it's maybe a cost outlay at the start, which is very worthwhile in the long run. So as I say, I advocate it, and I'd like to see more of it actually, because it's highly beneficial. But unfortunately, we don't see enough of it at all in Qatar. And then just to address the adjudication question, which is whether we might see some form of adjudication perhaps in Qatar. Some may remember the initiative called Q Construct in 2014, which didn't go anywhere, unfortunately, but where a number of members of the dispute resolution community in Qatar got together and drafted a set of rules which were optional for parties, but would have given that swift access to a binding decision in 30 days or whatever. Unfortunately, when that went through the stages of regulatory approval, it wasn't agreed. And so, the sticking point, and of course there are optional solutions out there. RICS have got something called the CAP, I think it's called, Conflict Avoidance Pledge or something. And it's exactly the same thing, but it's optional. And the problem is, if it's not contained in legislation, then the decision isn't enforceable in the same way that an arbitral award or court judgment is, or perhaps now a settlement agreement that's the result of mediation, as I was saying before. So really those swift decisions about disputes which are binding and enforceable are lacking in Qatar, and I can certainly see some space for Qatar to do something about that in the future.
There is one more question for you, Mrs. McDonald, at the very end almost. It's related to the PPP.
I'm reading out loud a question to Pamela, if I may. How likely is it that arbitration will be the dispute resolution mechanism of choice in PPP contracts? And would it be subject to the approval of the Prime Minister? In my view, it's highly likely that arbitration agreements will be contained in these PPP contracts eventually. That's just my opinion. And I think it's also really important that it is the forum, and then it's not the burden of the Qatari judiciary to address these complex disputes that are arising from such complex mega projects. It should be addressed through arbitration, through a panel of experts that gives you all of the flexibility that we know exists because of arbitration. Yes, it would require Prime Minister approval because these projects are public benefit projects, and it's being let by Ashgal, which is a public body. That's an administrative contract, and under Article 2, you're going to need the Prime Minister's blessing. That doesn't necessarily mean that we can't do it. We just need to do it. And I think parties will probably start to pressurise Ashgal to do it. I've got a feeling that's under very close consideration at the moment.
Thank you very much for answering these questions. Mr. Williams, would you like to also address the public with some of your answers on questions you received?
I got one which was in Arabic.
Ah, okay. Which one? Let us find out.
There does appear to be a question at the bottom now, Thomas, which is...
Yes, there is one which is put by Joseph Dyke.
Let me have a look at that.
Okay.
I would agree. Jonathan, go on.
Sorry, Dr. Minas, there was a clarification on an earlier question, which actually raises a separate point. I wonder if I could just answer that, which also might give Thomas a chance to think, having only just seen this additional question.
Okay.
Yasin El Shazi, who asked an earlier question, has clarified that I hadn't understood the terminology he was using. So thank you for the follow-up on that one. And he said it's, in terms of the neutral hearing assistant, it's a reference to somebody who participates to ensure that the expert in a virtual hearing is independent. And thank you for clarifying, because the terminology I know for such a person is a neutral observer. And again, it's a great question in the context of virtual hearings, because there's a lot of due diligence paranoia around whether, if somebody is sitting on their own at home or in their office, a witness or an expert, they might be being assisted when they're giving evidence. And a lot of people are concerned about how you prevent this. And there's a lot of solutions out there, from simple solutions like counsel asking witnesses to take the webcam, show around the room, show who's in there, show the doors closed, show what's on their desk, and again do that at any other time in cross-examination as required. There are techniques such as placing a full-length mirror behind them, so there's a reflection from the webcam and you can see what people are looking at and who's in front of them. A quite low-tech, cheap and useful way of doing this is people having a second Zoom feed from their mobile phone or tablet placed alongside them or slightly behind them. We also have people using things such as OWL cameras, also known as 360-degree cameras, which give an alternative video feed to show who's in the room. And one unfortunate downside is they're quite expensive, especially if you have a lot of people giving testimony, but also they don't see what's on the screen. Now, what that gets me to is this neutral observer, and that is where, let's say an expert is giving evidence in London for a Qatar seated arbitration. You have somebody independent go and sit with them whilst they're giving evidence and observe them giving evidence. And in my mind, it's not a practical measure, because in some senses it defeats some of the benefits of using a virtual hearing format, in that there's still travel, there's still some physical complications. But if there are genuine concerns about whether somebody's going to be assisted or the independence of them, I actually think it's the best way of preventing that. If there are real concerns, somebody independent in that room is a good tool to help. So I hope on my second attempt I've got to the question that was being asked there. And I'll hand back to you, Dr. Minas.
Thank you. So, Mr. Williams, I found the Arabic question. Let me tell you, I will make just a translation, and you will find out if this is the question to which you can find an answer. The question is saying, is it possible for the arbitral tribunal to render an award, and I believe he's talking about a final award, without enforcing it before the payment of the fees? This is a question coming from Bahrain.
It would never be a final award, because it wouldn't be dispositive of all the issues before the tribunal. It could only ever be a partial award, but it's nevertheless enforceable as a result.
All right, so I think the person from Bahrain received your answer. All right, so now we pass to Mr. Faupin. Mr. Faupin, I have a question for you. Ready for the question?
Tell me if I can answer it. I would be happy to do it. Yes, tell me.
Very good. So my question is, of course, France is part of the European Union. Mm-hmm. And as we know that the European Union has a lot of commercial ties with, I would say, the GCC countries, And as you can see, there is a question of between two economic blocks. We can think about a solution for this kind of recognition of not only arbitral awards, but also of judgments. What is your perspective on this?
Well, yes, I mean, it's definitely interesting to see, to seek for solution between two blocks. It will request, first of all, to study the situation of each country around in the European Union first, to see what kind of convention, if they have already, with the other bloc. But I guess there must be only a few bilateral conventions of that kind. But it's always interesting to look at solution at a higher level, and at a level that it would involve the European Union and the GCC themselves. So yeah, I would definitely be in favor of solution of that kind. Yes.
Especially that if there is a free trade agreement between two economic blocks, in the chapter dedicated to commerce or in the chapter dedicated to investment, we may add like a section where it regulates the recognition, the reciprocal recognition of the judgments and arbitral awards as well.
Indeed.
Very good. So
Dr.
I think, yes, please.
Question, if I may, that Thomas was about to answer, because I think it would interest a lot of legal practitioners if they haven't tried the virtual hearings. From Joseph Dyke, Thomas.
Yes, I was just going to answer that question that he put to me and Jonathan, and I'm grateful for the opportunity to answer it. I learned how to be an advocate from watching others do the job, and there's no real substitute than watching people live. It's like anything in life. There's an immediacy to the live performance. So yes, there's no substitute to watching people actually doing it in person. But just because we now live in this brave new world of virtual hearings doesn't mean that you can't watch people do it live. You can still be in the same room as others. And I know that when I've been doing virtual hearings here, I've had my team members who are all junior lawyers. At least 2 of them have been called to the bar in England. They're sitting next to me and they can learn from me how not to do it. And there we are. I think if you're in a situation whereby you're all sitting in different rooms and the advocate's by himself, it inevitably lacks that immediacy. So I think in terms of learning how to do it, maybe you're at a disadvantage. Maybe Jonathan agrees or disagrees.
Yes, thank you, Thomas. I largely agree, but I would just add that I think any exposure to seeing your peers conduct advocacy is beneficial. And if we are in a changing world where in future a lot of the advocacy is going to be conducted virtually, then actually participating in a virtual hearing is a route to learning how it will be done in the future. The other thing I might add is it might give more opportunities for somebody who, you know, say you're based at Chambers in London or somewhere like that, there might not be opportunities for you to fly to an physical arbitration hearing. Whereas in a virtual world, you might have more opportunities, even if just for half a day, to dial in and watch and listen to advocacy that you might not have done if it involved flights and costs and so on.
Any other comments? Any other things you would like to add before we conclude this webinar?
Actually, I'd just like to add to what were Thomas and Jonathan saying. The stamina that we feel during an in-person hearing is far different from the virtual ones. Nevertheless, virtual ones are quite interesting and it's a new experience for everybody. But the stamina being in the room, cross-examining, examining, hot tubbing, this is the kind of experience that when you are present, you really feel the heat and the emotions and all this. So it makes it a different experience than the virtual ones, which we are missing right now, but still.
reminds me the big difference between watching a sport game in the stadium and watching it to the front of your TV.
Yeah, that's a great point that Claudia mentions, and I absolutely echo that. I find when conducting advocacy, by the end of the day, I mean, any physical hearing is tiring, but on a virtual setting, I find it much more tiring. And what I've seen in a number of instances, and the reason I mention this is because if anybody's looking at organising their first virtual hearing, it's a point worth considering. Shorter days or more breaks can be helpful just to combat that issue of how tiring virtual setting can be.
Any more comments? No? That's it? Okay. So, ladies and gentlemen, please allow me first of all to thank all the 5 speakers at today's webinar. I think we have been together for about 3 hours, and we have covered several topics, and the speakers made their best in order to give answers to all your questions. I will conclude by saying that this webinar is part of the Legal Week. We have one more webinar tomorrow in Arabic. The next webinar is going to tackle cybersecurity. So that's also a very important topic nowadays. And we are going to, of course, thank all the participants today who have attended with us from different countries, including, of course, the GCC countries, other Arab countries. I know that there are people watching us from Switzerland, Italy, Spain, and many more. So thank you all. And I hope you had a good time with us, with the speakers, and with the compliments of the Qatar International Center for Conciliation and Arbitration. Thank you, and see you next time.
Thank you.
Thank you, everybody.
Thank you.
No.